Hello friends, I am Karthik Kumar Agarwal Advocate and you are watching my channel Bharatiya Law. So in today's session, we will be having a look over the grounds for refusal of a trademark, and more particularly we will be having a look over section 9 of the Trademarks Act 1999, wherein the act specifically describes the absolute grounds for the refusal of a trademark. So to begin with, when we talk about the grounds for refusal, they are divided into two categories. One is the absolute grounds and the other one is the relative ground. So while absolute ground for refusal talks about the intrinsic value of the mark, uh, on which it loses its value as a trademark. On the other hand, relative grounds are the grounds for which it talks about the conflicting rights basically. So if you have a earlier granted trademark, so related to that you cannot have another trademark which is being registered. So now coming to the absolute grounds for refusal, which are there in section 9. When we talk about section 9 subclause 1, it describes three major grounds on which the trademark cannot be granted a registration. First is that it is devoid of distinctive character. When we talk about distinctive character, so it should have distinctive colors, distinctive features, any of the mark, which is not there in any of the prior marks. In particular trade, it should be unique. That is one of the feature of a trademark, that it should be unique. So if it doesn't show any uniqueness, it doesn't show any distinctiveness which makes it apart from the other marks, then it is one of the absolute ground for refusal. The another ground is that if in particular that mark shows its origin or depicts the origin of the goods, a class of the goods, or anything like geographical indications are there in a particular mark, so they would not be accorded a registration. Intended purpose is also one of the thing, if you are having a pill for headache, so you cannot get the mark registered as a headache pill, because that particularly describes it as a trade, so it cannot be granted a registration. Or marks which have become customary in the current language. So in general, we are using a particular language and the mark has been customary in that sense, so it cannot be accorded a registration. The example is Kashmiri Kesar, because Kashmiri Kesar is depicting the origin of that particular good, so that would not be accorded a registration. But the exception here is about the well-known marks, or something which has been used for a very long term. So if there has been a long-term use of any of the mark, then that can be accorded a registration. It's in section 10 also of the Trademarks Act that if there is a long-term use, the customary use is there, so you can have a registration afforded to it. And well-known marks in particular is a mark for which there has been, prior to the granting of the registration, it has been used at such a long interval of time that people have started recognizing it. For instance, reliance is a word, it's a dictionary word, reliance, but it has been accorded a well-known, it has been kept into the well-known segment, because now when we say reliance, so we start thinking of the Reliance Industries. On the other hand, when we talk about the Maruti, so Maruti is one of the name of Hanumanji. So, but now when we talk about Maruti, we immediately recognizes the car company, Maruti Suzuki. So that comes under the well-known mark. Now, when we talk about section 9 clause 2, so it also gives us 4 different categories of the mark which cannot be granted or which cannot be accorded a registration. First is that there is a public deception. If any of the mark is in such a way that it is going to deceive the public, then that would not be accorded a registration. Scandalous material will also not be granted a registration. Or if any of the mark hurts the religious sentiments, religious feelings, so that could also not be granted registration. There have been instances earlier also that certain religious feelings have been hurt by the particular mark, particular usage of a mark, so they have not been accorded a registration. If I'm not wrong, there were certain cases, not in India, but there have been cases in other countries as well, wherein the religious sentiments were hurt. So the government has particularly raised objections with the government of those countries that these marks should not be allowed to operate in the market. Similarly, in Indian context also, the government does not, or the office does not grant the registration to those marks, and that's a statutory provision that such marks should not be accorded registration. There is one of the act, Emblems and Names Act 1950, which gives a list of the national symbols, national emblems. So all those will also be prohibited to get registered. For example, Ashok Chakra. If you try to get registration of the Ashok Chakra in your name, that you would not be accorded registration, because that is prohibited under the Emblems and the Names Act 1950. So all these marks would not be granted registration. When we talk about section 9 subsection 3, so the shapes of goods which represent the nature of the good, or the technical result, something which is required for technical results or which gives substantial value to the goods, would not be accorded a registration. For example, the shape of the test tube, or the box with 4 wheels, because that is something which is general for a particular vehicle. So that would not be granted registration. These were some of the absolute grounds for refusal of the trademark. I hope you enjoyed this video. If you have any questions, you can always leave them in the comment section below. Please do like this video, subscribe to my channel, so the next time whenever I upload the video, you are there with the notification of it, and you can go and immediately start watching it. Thank you.